let us jump to the topic of article. Articles means those which have been originally formed at the time of incorporation or altered from time to time. Now, memorandum and articles are two different things. Memorandum is a very basic constitutional documents having those 7 or 8 clauses, 6 or 7 clauses, right? Articles are those which are subordinate to the memorandum, in which the entire internal bylaws and regulations are mentioned. That is, the members inter se. What is the relationship of the members inter se? Basically, memorandum defines the relationship of the company with the outsiders. Normally, how the outsider will come to your company, how the outsider will contract with your company, it will be more or less dependent upon the basic documentation of memorandum. But once you are members, what are the role of the members in the company? What are the relationship of the members inter se, that is among themselves? What is the relation between company and its internal members, that is its owner? How they are dependent or independent of each other? That is basically defined under the articles of association. So articles of association is that document which defines the internal rules and regulations that govern the company. In terms of section 5, the articles shall contain the regulations for management of the company. The articles are the bylaws, the rules and regulations which governs the management of internal affairs of the company. That is, what are the examples of internal affairs? Say, for example, how the company will follow the procedure of voting. I'm not talking about the legal aspects. I'm talking about our internal policies. How the company's shares will be transferred, how the company's transmission of shares will take place, how the buyback will take place, how the voting rights will be exercised. These are basically the internal regulations of the company. These are defined under the articles of association. How the company will forfeit its shares, how the calls will be taken, how the calls in advance and calls in arrears will be adjusted. These all are internal affairs which are basically defined under articles of association. So subsection 2 defines that articles shall contain such manners which are matters which are defined under schedule first. So what is schedule first? We had already discussed that in the schedule first, table F to J, there are different types of articles, and these types of articles have specifically mentioned 30, 40, 50 points. That what all points you can cover under the article. What are those points which I had already shared? The provisions of transfer of shares, transmission of shares, call money, advance and arrears, forfeiture of shares, buyback, transfer, transmission. All these points will be specifically covered in the articles of association. So this is all about the articles. What we had discussed in the earlier slide, the case law of Ashbury railway carriage only. This case law is divided into two parts. The first part was what the memorandum is all about. And in the same decision, the court has defined that what the articles are all about. The articles are the subsidiary document to the memorandum. That is a subordinate document to the memorandum, and it defines the internal powers, internal rules and regulations for governing the self-governance of the company, the bylaws of the company, right? So, of course, the memorandum is a superior document than article. The memorandum can have something which is against the article, but in such a case, who will be the major document? Say, for what I'm trying to say is, if your memorandum and article have some contradiction, always the prevailing document will be memorandum, because articles cannot define anything which is not again which is against the memorandum. The articles cannot define any such matter. So if there is any inconsistency between memorandum and article, always the memorandum will be preferred. Simple. So far, so okay. Now, some important points left in the memorandum and articles, some very basic points which we need to discuss. First is the entrenchment provision under articles. Section 5, subsection 3, 4, and 5 hardly matters. Now, this is very important. Entrenchment provision. Uh, be very attentive. See, normally the Companies Act have defined that how the decision making will take place under Companies Act. Say, for example, various sections are there in which it is written for this particular matter, pass the board resolution. For this particular matter, pass the ordinary resolution. For this particular matter, pass the special resolution. Right? Normally, what is an ordinary board resolution? 50, more than 50%. That is, if the majority says yes, the matter is yes. If more than 50% says no, the matter is no. This is basically simple majority. Under the Companies Act, there is also unanimous board resolution. That means each and every person sitting in the board meeting shall accept the resolution, then only it will be passed. If the single board member have rejected the resolution will be actually rejected, right? In the case of general meeting, there are two types of resolutions. First is the ordinary or simple majority. That is more than 50% of the members should accept the fact. And second is the special resolution. Special resolution means votes cast in favor must be greater than or equal to 3 times the votes cast in against. Right? We had discussed the fact in the first slide of our course. Now, entrenchment provision is something that, say, for example, in the law, in the Companies Act itself, it is written that for passing, say, for example, for conducting a buyback up to 25%, say, for example, for conducting a buyback up to a limit, special resolution is required. Special resolution is required is already written in company law. Now, entrenchment provision is, say, for example, if the lawmaker says for conducting this particular work, pass SR. So, can we pass an OR for that particular matter? Can you relax the legal contention? The answer is no. You cannot relax the legal contention already prescribed in the law. If lawmaker had said that you need to pass a special resolution for doing certain work, you cannot do that work simply by passing ordinary resolution. Because what you had done, you had degraded the legal requirement, which is not acceptable. You have diluted the requirement of the law. That is unacceptable. But can in the article, we can define that although the lawmaker has defined the special resolution, that is votes cast in favor should be 3 times. Our company has a policy that this particular matter will only be passed if unanimous resolution is there. Now what we are doing, we are actually making the compliance of the law more stricter. Can such be provisions be defined in the articles? Yes. And what are these provisions called? Entrenchment provisions. Entrenchment provisions means those provisions that you are actually making the decision making more stricter than what is defined under Companies Act. Say, for example, for a particular matter in the company law, it has been defined that an ordinary resolution is required. Now, can we make such provisions? Can we make some such amendments in articles that no, our company will only proceed with such types of decisions after passing SR? The answer is yes, we can do so. What we had done, we had raised the standard of decision making beyond the law. You cannot reduce the decision making what is given under the law, but you can always make stricter compliance for the company in the terms of decision making. So entrenchment means to make certain provisions more stricter to comply, right? But how the entrenchment provisions will be inserted in the articles, there are two types, there are two manners. Either sorry, either at the time of incorporation, you you mention each and every entrenchment provision and get your articles registered by the with the ROC only at the time of incorporation itself. If you have not done so at the time of incorporation, now you are an existing company. If you want to alter or amend or insert any entrenchment provision, any stricter provision, you need to pass a resolution for it. Now, what is this resolution? This is not a decision making. This is just a resolution to make an entrenchment provision inserted in the article. So to insert an entrenchment provision for any particular matter or group of matters, you need to first pass a resolution. Now, what will be that resolution? It will be either OR or SR or what? It is defined. So to insert the entrenchment provision, one option is at the time of incorporation only, you have inserted the provision. No issues. But once the company is incorporated, now you need to amend the articles for the provision of entrenchment. And for the amendment, if you are a private company, you need to pass a unanimous members resolution. 100% of the members, if they agree to insert the entrenchment provision, then it will be inserted. And if you are a public company, at least special resolution is required. You pass an SR. What to do for what we are passing? To insert an entrenchment provision for a particular matter. That from today, if you pass an SR, then this particular, say for example, the matter of buyback. For this particular matter, if the lawmaker says SR, we will be having a stricter compliance of passing unanimous resolution. By passing an entrenchment provision, you cannot relax the legal requirement. You can make the legal requirement more stricter in its compliance. Right? Another types of, not only these types of decisions, I'm just giving you some examples of decision. Say for example, the board meeting concept. Your lawmaker says that every company shall have at least 4 board meetings. Now, can I pass a special resolution and make a provision that no, our company will only have 2 meetings? No, you can't do so. You cannot relax the legal requirement. But can our company defines that our board meetings will be held at least 6 times in a year? Yes, we can do so. What is expected out of law? 4 times. We are making it stricter. No, we will meet at least 6 times. But for that, you need to pass an SR in case of public company, and unanimous resolution in case of private company. Right. Say, for example, another type of example, for a general meeting, at least 21 days clear notice should be given to the memorandum. Can we define that? No, we will only serve 7 days notice. No, you can't do so. But can your company decide a provision that at least 30 days notice will be served to the members? We can do so. This is making the legal requirements more tough. What law says 21 days. We are giving at least 30 days notice. So these are entrenchment provisions. And how they will be passed? In case of private company, unanimous resolution. In case of public company, a special resolution. So far, so okay. This is the concept of entrenchment provision. Last of the topics, we are concluding this memorandum and article in a few minutes. What is the effect of memorandum and article? Once the company is incorporated, once the memorandum and articles are registered, these are the binding documents, binding upon the company, binding upon the members. That is, whatsoever it is written in the memorandum and article, the company, its directors, its shareholders, everybody, its members shall follow the same. If you need to amend it, you can pass a special resolution, ordinary resolution. You can pass the legal procedure in order to amend it. Otherwise, you need to follow the memorandum and article as your basic documents. And it is binding upon all the members, all the directors, and the company itself. This is the effect of memorandum and articles of association.